Namaskar viewers, hello and welcome to Sansad TV. I'm Tina Jha, you're watching Perspective. The spiraling controversy surrounding the alleged recovery of huge piles of cash from the official residence of Delhi High Court Judge Yashwant Verma has once again precipitated concerns over the urgent need for judicial reforms, transparency and accountability. Vice President and Rajya Sabha Chairman Jagdeep Dhankhar has urged lawmakers to address these concerns at the earliest in order to restore public trust in the judiciary. Earlier this week, he chaired a meeting of all political parties to discuss how a mechanism for ensuring judicial accountability could be evolved. In a statement then in the upper house, the Rajya Sabha chairman referred to the National Judicial Appointments Commission created by a law passed in 2014 by Parliament with support from parties across the political spectrum but scrapped by the Supreme Court in 2015. Asserting that there is no constitutional provision for the review or appeal of a constitutional amendment, the Rajya Sabha chairman emphasized on the need for greater cooperation among the executive, legislature and judiciary to ensure greater accountability. So what are the challenges in holding judges accountable? How can the NJAC address this issue? Also, what more needs to be done to ensure a more transparent judicial system in the country, one that commands greater faith of the public? We'll try and get perspectives on some of these crucial aspects and much more from two distinguished guests joining us on the broadcast. I'm pleased to welcome Justice S.N. Dhingra, former Judge, Delhi High Court. Sir, thank you for your time. Welcome to Sansad TV. Also joining us is Professor Dr. Manoj Kumar Sinha, Director, Indian Law Institute. In fact, he was earlier Director at the Indian Law Institute. He is currently Vice-Chancellor, Dharmashastra, National Law University, Jabalpur. Thank you, Professor Sinha, for your time as well. Welcome to the program. But before we begin the discussion, let's listen in to the remarks of Rajya Sabha Chairman Jagdeep Dhankhar on the matter.
इस सदन ने गरिमा का ख्याल रखते हुए मर्यादित आचरण का प्रदर्शन करते हुए 2015 में एक राय से एक कानूनी व्यवस्था बनाई थी. And that constitutional structure that emanated unanimously with one abstention from the Parliament, endorsed by state legislatures, should be rule of law because it was sanctified by the Honorable President by appending her signatures under Article 111. Now is the befitting occasion for all of us to reiterate that, because that was a visionary step endorsed by Parliament. And imagine if that had taken place, things would have been different. For honorable members of Parliament, I seek your suggestions on one very important point. What emanated from Indian Parliament as a historic development with rare convergence of unity since independence, found acceptance by needed state legislatures. We need to reflect what happened to that. Under the Constitution, there is no provision that allows anyone to tinker with that. There is no constitutional provision of review or appeal of a constitutional amendment. If there is legislation in the country by Parliament or state, judicial review can take place on the anvil whether there is conformity with constitutional provisions. Now, before the nation, there are two situations. One, what emanated from the Indian Parliament, duly endorsed by state legislatures, sanctified by the Honorable President by appending signatures under Article 111. And second is a judicial order. Now, we are at crossroads. I strongly urge members to reflect. There can be no breach by any institution of what emanated from the Parliament, endorsed by legislatures. And that should again, I reiterate, be the mechanism holding the field. It is time for us, having seen such extraordinarily painful scenario. I do not wish to go into the merits who is right or wrong. Innocence is something which we take at a very high level till someone is proven guilty. So members would think, and therefore the step taken by me, with the benefit of wise counsel and experience of leader of the opposition and leader of the House. And rarely there has been convergence that the ruling party president is leader of the House here and main opposition party president is leader of the opposition. So we will come back to the House on this very critical, important issue that concerns much beyond judicial mess. It concerns sovereignty of Parliament, supremacy of Parliament, and whether we are at all relevant. If we effect an amendment in the Constitution and that is not executable, if a constitutional amendment is not executable, I have no doubt the Parliament is possessed of the power, any power in any institution, to ensure what emanated from the Indian Parliament, sanctified by a requisite number of state legislatures, holds the field.
So we will discuss in the course of the program the NJAC, the remarks of the Vice President and the Rajya Sabha Chairman on the 2014 Act and the Supreme Court striking it down. Also the recent clamour on bringing the NJAC back to do away with the system of judges appointing judges, perhaps a mechanism that's prevalent nowhere in the world except India. However, at the outset, let me get in the views of both our guests on the aspect of corruption in judiciary, something that the recent case has brought to the fore once again. But since the matter is under investigation, we cannot comment much on whether the judge in question is guilty or innocent. But we will certainly try and address the systemicity of corruption within the Indian judiciary. Looking at the several prominent cases, in fact, that have also taken place in the past, but how the existing mechanisms have proven to be inadequate in checking corruption in the Indian judiciary. Justice Dhingra, your views first on the corruption in judiciary, what perhaps is sort of sustaining corrupt practices in the Indian judiciary, the challenges that are there, but how we are not able to address them because the existing mechanisms are inadequate.
You see, the existing mechanism in respect of corruption in judiciary has been so linked and with the independence of judiciary. That is the most unfortunate thing that we have seen, that whenever fingers are raised about the corruption, a cry is made that independence of judiciary is being affected. The result is that no mechanism has been evolved so far where by the Supreme Court or by the High Courts in-house in order to curb the menace of corruption, and Parliament has also failed to evolve a mechanism in respect of corruption. You see, presently the only thing available is impeachment of the judge. And if the judge resigns, then there is no impeachment also. And the case against the judge either is dropped after resignation or, you see, it lingers on for years together that people forget what was the kind of corruption. And you see, glaring example is of Justice Shamit Mukherjee, who was of Delhi High Court. You see, there was ample evidence against him that he was getting his judgment written from the very party against whose case was there with him. And he was accepting bribes and even women were being sent to his house. All this was collected by CBI. Right. While the investigation was not going off Justice Shamit Mukherjee, the investigation was going off in respect of another contractor. And accidentally, the police stumbled upon this evidence against Shamit Mukherjee and it was brought to the notice of Chief Justice. Shamit Mukherjee was made to resign. It was in sometime in 2003, of course. Now we are in 2025. The case is still hanging fire in the courts. Same is, you see, case of Mr. Yadav, Nirmal Yadav, who was in Punjab Haryana High Court. See, there also a envelope containing 15 lakh was wrongly delivered at the house of Nirmal Kaur, Justice Nirmal Kaur, by the Munshi of an advocate, while it was to be delivered at the house of Nirmal Yadav. And when the things, you see, came out in the open, you see, the Nirmal Yadav case is still going on. That is also about 20 years, the case is going on. See, we have made our judicial system almost ineffective against those criminals who are powerful, who have money, and who can manage the things. If there is a Supreme Court judgment, I cannot give citation right now, which records that in India, a criminal case can be lingered on for any numbers of years if you have enough money. And this is, you see, this can be seen by anybody. Therefore, this present judicial system, at least criminal justice system, is ineffective in punishing even otherwise. And as far as judges are concerned, if there is corruption in the office and linked with the judgments, you cannot prosecute them. You cannot file a case because you need the permission of the Chief Justice of India. In case of trial court judges, of course, the IS and service rules are applicable, judicial service rules are applicable. You can proceed against them. But what about High Court judges and what about Supreme Court judges? Nothing can be done except impeachment. So, and then we come on appointments. I find it very, you see, it is very difficult to digest.
We'll come to the appointments in just a bit. Let me also bring in, Professor Sinha about his views on corruption prima facie. The fact, Professor Sinha, and something that Justice Dhingra also elaborated is, there is a problem, and a grave one, which time and again we've been discussing, that there are corrupt practices prevalent in the Indian judiciary. The existing mechanisms, perhaps too, are inadequate in addressing the problem. The numbers speak for themselves, because between 2017 to 2021, this is 4 years ago, the data says, the Union Law Ministry in fact informed the Parliament that 1,631 complaints regarding judicial corruption were received and forwarded to the Chief Justice of India or the High Court Chief Justices. The outcomes of these complaints remain shrouded in secrecy. Justice Dhingra cited several prominent cases as well, and we have yet to see outcomes in any of these. What is the root cause of the problem according to you? Is it the backlog of the cases? Can we say the pendency of the cases is what is fostering this systemic corrupt practice which is prevalent and which has become so big in the Indian judiciary at various levels?
Thank you very much for having me. I don't think that pendency is an issue which linked with the corruption. I agree with the Honorable Justice Dhingra sir, what sir had said about the procedure, the process which has been laid down, and particularly under Indian Constitution for the removal of the judges is mentioned under the Article 124, paragraph 4. For the same applies for the High Court also. But as Sir Lordship has already mentioned, it's very difficult and many times judges resign and subsequently nothing. If I take your question, what you have said, 1,000, I believe, I'm not quite sure whether that involves only the constitutional court corruption cases or it starts with the subordinate judiciary to the higher judiciary. If that is the case, subordinate judiciary, as identified, the High Court is competent to take action, and there are cases, disciplinary action, number of things were taken by the respective High Courts when it comes to the subordinate. When we come to the Constitutional Court, High Court and Supreme Court of India, we have cases, but unfortunately we jump to the conclusion, and conclusion is that we think that every judge is corrupt and things are not going in a proper manner. That is not the case, and whenever some incident happens, that particular time it's become very natural, that time it's become very concerned.
Right.
We have to link two things. judicial accountability and judicial independence. And I believe, and many of us believe, judicial independence is very important. Mixing everything, making judicial accountable to the legislature, executive, it will create a lot of instead of solving the problem, it will take in a different direction. When it comes to the faith in a system, if I say honestly about the executive, judiciary and legislature, faith of common man, I'm talking about the common man. Common man, without any hesitation, they say, I have faith, and that is the reason they go to the court, because people have a faith in the Indian judicial system, whether it's a subordinate court, it's a higher court, or or Supreme Court. So people have a faith, and that is the reason for the civil matters and also civil matters. People go desperately to the court and find out a solution. They have a hope. These are the aberrations. These needs to be addressed. This cannot be addressed by appointment mechanism. These are the moral questions. These are the ethical questions. And I believe that almost like a large number of judges are, they try to, remain dedicated to their profession. They follow the ethical standard. They follow the morality. But still there are aberrations are there which needs to be addressed. But how to address, whether it's going to be changing the appointment method that will solve the problem, my answer will be no. Whether bringing NJAC will solve the problem, my answer will be no. I think the judges, those who are there, and this system itself will take a mechanism. And even in this present case, the way the response of the Supreme Court of India, the way they have uploaded everything on the website, it appears the essential effort is going on to dig out the original truth behind the entire incident. So we have a number of issues. I believe we need to look into that. I don't think that pendency has anything linked with the corruption. There are different kind of corruption. I agree with you that exists in the subordinate court in a different way. But in a higher court, when we have around 700 or 800 high court judges in the respective courts and 34 in the Supreme Court of India, these are very less.
No, but the manner in which these, cases of corruption are even handled and how they differ from, other public officials is a matter of question. You're right that, appointment of judges may not be related to addressing the issue of corruption. But the larger point here is also about ensuring transparency in a democratic institution. Justice Dhingra, your thoughts on how NJAC is going to bring about transparency, at least in the appointment of judges, because the larger outrage here is also about how nowhere else in the world, but in the world's largest democracy, judges are appointing judges, and which is an opaque system. So the NJAC, which was one step towards bringing in that transparency, that sunlight into the opaque system, was blocked. Do you think NJAC is one alternative, one way forward to at least put an end to the practice of judges appointing judges?
You see, it is unfortunate that in India, judicial institution has been captivated by about 250 families. See, today I was listening to Justice Karju. He was saying that, Justice Verma is very close to me. So my views will be biased. I knew his father, he was a judge. I knew the whole family. He did not give his view. But I will give you an example what kind of judges are being appointed. See, Justice Altamash Kabir was of Supreme Court. His sister was practicing in Calcutta. She was doing labor court cases. At the age of 58 plus 6 months, she was made High Court Judge of Calcutta High Court. Now, this was unique example where a person from advocates was made High Court Judge at the age of 58 plus 6 months. And that also, despite the recommendation of Chief Justice of that Calcutta High Court that she is not fit for being appointed as High Court Judge. Now, when I was in Delhi High Court, see, Justice A.P. Shah was the Chief Justice. His appointment, he was considered one of the eminent judges. He had given very prominent judgments. His appointment to Supreme Court was blocked by one of the collegium judges. And why it was blocked? Because his father or his relative had blocked the judgment of that collegium judge's relative. So, in effect, what is happening is, see, I know cases in Delhi High Court, at least where I was working, that, you see, I was talking of Justice Shah. Two judges of trial court were superseded because Justice Shah considered they were not good enough to be appointed as High Court judge. When his own appointment was challenged, at the behest of a Supreme Court judge, he upgraded them and brought them to High Court. Still, he could not be made a Supreme Court judge. But this is how the appointments are done. See, every Chief Justice of every High Court spends more time in going to collegium judges than spending time on his work. Right. If this is the way that you degrade, actually I consider it is degrading of the judges, that they have to go to collegium judges to get appointed. Then, you see, you are appointing judges who do no work. We had a judge in Delhi High Court, when he left Delhi High Court and was appointed Chief Justice, he left behind 250 files which were heard but not decided.
Professor Sinha, you know, that makes for an interesting argument, because corruption is not just about receiving bribes or kickbacks in favor of judgments.
I say yes. Basically, these judges, this appointment is corruption based.
Absolutely.
When you appoint your relatives, you see, when I was a student of law in 1976, at that time there was no collegium. Even at that time, you see, I asked my professor how you can be appointed to High Court or Supreme Court. He said, it doesn't matter you know law or not. It matters who is your father-in-law, who is your mother-in-law, who is your brother-in-law. So this was at that time.
You're right. And I think that has to stop. Professor Sinha, the question to you...
Even now, it is the same thing.
Yes, in fact, that's the question.
Appointment is based on corruption. I call it high-level corruption.
That's where I want...
basic appointment is based on corruption. I think it is but natural that judges will be corrupt.
Sure, that's where I would like Professor Sinha's intervention. You know, corruption is not just about receiving bribes and kickbacks. It's about resorting to unfair practices in getting the appointment that perhaps you do not deserve, but you're getting it not as per law, as per, who your father-in-law or your mother-in-law is, something that Justice Dhingra also spoke about. He cited examples. The question and the public opinion at the moment, Professor Sinha, is two institutions, the Parliament, the judiciary, pillars of the Indian democracy. If the Parliament of India can reflect the will of the people, why not the judiciary? Why can the judiciary not reflect the will of the people in terms of who our judges will be?
I think, I would like to answer in two phases. Like in the first phase, appointment of the judges, which Constitution has a provision under Article 124, and Lordship gave an example nicely for the both. During 1976, he said the same problem which exists post a new system which came into existence, collegium system, in 1993. There are aberrations, there are misuse of the system, or preferences were given to the. That are the cases which needs to be addressed, and rightly pointed out with a very strong example how system has been tilted out, managed in favor of certain individual. I still believe, because collegium has not come on its own, it has come because of the Supreme Court Advocates on Record Association. They go into the court. There are 4 important judges cases starting from the S.P. Gupta in 1981, 1993, 1998, and then 2014. It has not come all of this sudden. And who brought it? It's a Supreme Court Advocates on Record. They have gone to there, and the power has been given a collegium system. And in third case, it has been the scope of collegium has been enlarged, membership has been enlarged from the 3 to 5, and that process has come into their consultation has become more or less as concurrence. System is nice, it works where they are the person who knows. And of course, it should not be what the concern expressed by the Honorable Justice. I totally agree with that. While selecting they must behave like a Panch Parmeshwar, or like, it takes me to the Premchand, Munshi Premchand, Panch Parmeshwar. So while appointing a person, very ethical and moral question, a very high standard has to be set, and then appointment is done. You just see in the United States, it's a political appointment. You are talking about so that is so our appointment is much better the way they are there. They consider the Republican judges, Democratic judge, whether it's a lower court or the Supreme Court of India. So the executive believes how judge will work, and people perceive that how Supreme Court of United States will act in this case, because 4 judges are appointed by the Republican, remaining by the Democratic. So we should not outrightly reject, because this system judges have not brought the system, collegium system has not come, but they looked into and they found this is the system which work. And of course, the points which highlighted, points which you have been also highlighting, which needs to be addressed effectively. And the time has come where a lot of changes has taken place 2015 onwards. Now the credentials of individuals are uploaded. There are a lot of changes have taken, but still there are a lot miles to go. So judiciary has to come with proactive, I believe, and in the collegium system, who is getting maybe some public opinion or something can be engaged. Some feedback. Of course, there is a feedback. Governmental feedback is there to who has to be appointed as a judge.
You're
even
right.
after recommendation.
So we'll try and understand where the problem lies then, Justice Dhingra, because the Constitution provided that the government, in consultation with the Chief Justice, should appoint the judges, and this system worked quite well until 1975, when the emergency changed everything. It's been several decades since the emergency as well. It's time we return to normalcy. We have a transparent system of appointment of judges. The collegium is quite an opaque system. The NJAC tried to undo that system, but of course the Supreme Court struck it down. The question here is, where is the problem with the NJAC? Because in the NJAC also, the Supreme Court has been given the upper hand. It's the Chief Justice of India who will be the chairman of the commission. Most of the members who are in the collegium will be part of the NJAC. The commission is just an independent one. It is more representative because it includes members of the government and other bodies. So where does the problem lie? Why does the Supreme Court think that the NJAC will compromise on the independence of judiciary?
You see, I think it is not the question of thinking. It is the question of grabbing the power. The Supreme Court has, taken this power away from executive of appointment of judges. And Supreme Court has enjoyed this power for quite some time. The sons and daughters and relatives and friends from the chamber, same chamber, see those who become judges, their chamber persons are appointed judges. If you take away this power, obviously the person who has been enjoying power will feel it. Otherwise, I don't find any reason that Supreme Court should have evolved a mechanism either itself or wide ranging choice before it. Then there is, alternate available in the Constitution also. In Constitution, there is provision for Indian Judicial Service, All India Judicial Service. Now this All India Judicial Service, if implemented, would have provided you good judges, experienced judges, and judges with specialization in different branches to the High Court, Supreme Court, and taken up to this. Today the situation is that a High Court judge does not know the difference between what is attempt and what is preparation. A judge says, you must have read this recent judgment of rape. The judge doesn't know that opening of taking down clothes, pressing, the private parts, is an attempt or it is a preparation. Similar was the other case. If you are appointing by way of collegium judges who are practically uneducated about the law, then where does the collegium stand? There were 2 appeals which had come before Supreme Court from Himachal Pradesh High Court. where the Supreme Court made the observation, we are unable to make out what the judge has written. The appeal was accepted only on this ground that we are not able to make out what the judge wants to write. That is the capability of the judges appointed by you, by collegium. So collegium has not recognized its own weaknesses, and NJSC provided a very good opportunity. 3 judges from the Supreme Court, 2 public persons and 1 law minister. Now where was the question of overruling Supreme Court? Because Supreme Court Chief Justice would have been the chairman of the committee. Then the recommendation, only objections could have been raised by public person that this judge is good or not, this person's, what is his credentials. They could have brought it to the notice of Supreme Court. Now also the Supreme Court considers that its recommendation must be treated as final. Even if IB reports that a judge is corrupt, and Supreme Court says that no, we'll go by our recommendation, the president has no choice but to appoint him.
You're right, and I think that is where the larger concern and the problem is, Professor Sinha, because in the world's largest democracy, if the public trust begins to erode in democratic institutions, it is a matter of serious concern. How do you think, what is the way forward to ensure that the public trust, the public confidence is regained in an institution of the level of the judiciary?
Just let me put a word, like I think transparency is the best way to address this issue. The way person is selected, appointed as a judge, his credentials should also be uploaded in the website well in advance. So engagement of, or even if any public wants to share his view, he or she feel free to give. So I feel the process should be more transparent, and that was the big issue in the functioning of the collegium. And collegium, this may be an occasion where judges will find a competent, if judges whosoever is be appointed, I'm not going on the family affiliation, but competence is very important. Capability, the person who has credibility, who has integrity, who has competence, and who has established reputation in the society, even if he is close to the one judges or family, just because of that reason he should not be discarded. Okay. But if these qualities exist in an individual, is there. Just to add one thing which I, with all due respect to the judge, collegium judge, the NJSC judgment we have to see, the 4 judges have given different reasons, and they said ki independence of judiciary is a basic strength. They said ki reciprocity will come. Justice Kher has mentioned, if I start accepting NJC, then I have to be reciprocal. So one appointment by the politicians, one appointment by me. So this problem will not go away. The 4 judges have given a different, and they emphasize the independence of judiciary is a basic structure of doctrine. I insist upon, there are issues, there are challenges, but that challenges need to be removed gradually, and people, honorable judges should work on that and then restore the faith. People, I still believe strongly that people have faith.
That's the most important thing, because NJSC or any other mechanism going forward, the opaqueness in the system has to go, and this is the time, because this has been a long pending debate. We've been talking about it for several decades, but we stand where we were decades ago. Justice Dhingra, I'll take one last comment from you on the kind of sweeping reforms that you think, aside the NJAC, what exactly does the Indian judiciary need to do, or what exactly we as a system need to do to ensure that the public trust in judiciary remains intact, at the same time the judiciary does not risk losing its credibility?
See, I think it is time that judiciary now should move towards specialization. We should have specialized bench, for criminal bench, specialized service bench, specialized constitutional bench. It should not be that the bench changes with the change of the face. What is today happening is that benches are constituted according to the litigant. It should not be there. There should be one permanent bench of criminal court where specialized judges should be appointed. One permanent bench of constitution where constitutional experts are there, and they understand the law. Similarly, service matter, writ petitions, etc. You have 34 judges, you make 5 benches. Or with 3 judges bench, you can make 7 benches, 8 benches. So, but they should be specialized benches. Today we have specialization in all fields. In engineering, in medical science, you see a doctor who is a heart doctor, he doesn't take care of eyes cases. But here we have a system in which a judge who has been all along his life taking only taxation cases, he suddenly becomes a criminal justice, criminal judge. So, then they behave like uneducated judges, I am sorry to say so, because they have to spend months in hearing arguments, because they have no basic knowledge. If a judge has no basic knowledge of criminal law, he won't be even able to distinguish between statement of 164 and 162 and 161, old CRPC. So the problem is we don't have specialization. Every judge considers he is master of all laws, and advocates are there to teach him if there is anything, and judges act like umpires. Even at trial court, the judges act like umpires, not like judges. They have no concern with truth. They don't find out what is the truth. They simply say who has argued well. If this is the way judicial system works, we cannot do justice. The whole system fails in providing justice. We are, actually judges are acting like umpires, not like judges.
Very well said, Justice Dhingra. The fact that you've been in the system, you know about the grave challenges that exist at multiple levels, yet we've not been able to, we've been discussing it for several years, but not been able to find a mechanism that works towards addressing all of these challenges. And that's where the Vice President of India, the Rajya Sabha chairman, has called on all political parties, the lawmakers, to sit together and work on a mechanism where all of our pillars of democracy are not pitted against each other, but they're working in tandem with each other for greater transparency and accountability in the system at large, which is for the larger public good. So we hope that happens quite soon, but for now we'll have to wrap up the program. Time allows me to take up only that much on this edition of Perspective. Thank you once again to both our guests for joining us on the program, sharing your thoughts, your views with us and our viewers. And to you viewers, thank you very much for your time as well.